Right, this is case number 18-149034. This is Macomb County Community College versus Kayala Boykins is the last name, and that is before the court on a subpoena, the issuance of a subpoena. Your appearance at this time for Macomb County, Macomb Community. All right, do I have Macomb Community College on this morning? Do I have Boykins, last name Boykins on this morning?
Yes, Judge, I apologize. I'm here on that matter. Good morning. Keith Cox of Winters and Associates on behalf of the plaintiff.
All right, thank you, counsel, and good morning to you, sir. State your P number, if you will, for the record.
I'm sorry, P59146.
Thank you, sir. All right, I'm looking for Ms. Boykins this morning. Have you seen her at all?
No, Your Honor. We've not heard from her. We do show that the subpoena was personally served, but we've not received a response from her either in writing or by phone.
All right, very well. The court, it looks like a notice went out from the court regarding this matter as well. So the defendant has not appeared regarding this matter. Your pleasure this time, counsel.
Well, Judge, I don't know the court's policy. Certainly could request a bench warrant unless the court determines that a show cause is the appropriate course. But I guess we move for the entry of a bench warrant for the amount of the remaining judgment balance.
I'm sorry, Mr. Cox. I'm going to set the matter on for show cause and set up the matter for a show cause hearing. And of course, if the defendant does not appear for the show cause here, the court will entertain your motion for entry at a bench.
Very good.
So the defendant is ordered to show cause on. We'll give you a date just a moment, counsel.
Oh, pardon me. November. Okay, November 16th. November 16th.
16. November 16, 2022, and that's going to be at 9:30 a.m. So, counsel, if you get the bench warrant paperwork over to me with that date on it, you can email it and not the bench warrant, the show cause paperwork, and I'll sign off on it with that date being the date for the year.
Very good, Your Honor. Thank you.
Thank you, Mr. Cox. Good to see you. Sir?
I'm also here on 657.
Well, let's see if we can cut the line and get you that out. All right. This is case number 22-179-657. This is Munich Insurance Company versus Marathon Garnishee Best Buy Services. It looks like the matter is before the court. I have it set on for just a hearing on today's date. Counsel, your appearance for the plaintiff, Munich Insurance.
Good morning again, Your Honor. May it please the court, Keith Cox of Winters and Associates on behalf of the plaintiff, P59146.
Good morning, Judge. David Burkle on behalf of the defense, P39098.
Thank you. So are you appearing for Marathon or your Best Buy? Which one are you here on?
I am appearing for the reference gas station. I think it's called Best Buy.
All right, got it. So that's the full name. That's I thought it might be a garnishee within it or something. All right, very well. So what's going on here? Somebody update.
So this was
Go ahead, David.
yeah. So thanks, Keith. So Judge, this was a bad gas situation. There was an issue with one of the tanks at this particular Marathon station, and several vehicles were damaged as a result of the use of bad gas. Those claims were resolved. This particular claim was not resolved because the documentation submitted by Memix insured reflected the purchase of gas from a Marathon station in Romulus, station number 185918, which is not the station that is where the bad gas was purchased. That station is station 182980 in Detroit. So that was the original reason the loss wasn't adjusted and paid. And so that's where we're at. Mr. Cox sent me a note some time ago, but it contained the same information that had previously been provided to the insurance carrier for the gas station. So all I need from Mr. Cox, I guess, is a document reflecting the actual purchase from this particular station on the day referenced, and we should be able to get it resolved.
All right, I take it the two of you have had an opportunity to talk about this a bit, Mr. Cox?
We've emailed back and forth, Your Honor. And I think that's a fair representation of why the claim's been denied. I think there's been additional documentation provided, but certainly not satisfactory to defendant to pay the claim yet. So we're still working on this.
All right, are you hopeful that there is such a thing as a document that might be congruent with the claim in this matter?
Yeah, Judge. I mean, I don't know that we have exactly what they're looking for, but we do have additional documentation that I have previously provided. So I guess it's just a matter of working through it, I guess.
All right, so I guess a part of my concern here is to, is to determine whether or not I should be setting this up on some type of discovery schedule, or whether a continuance for a short period of time, maybe 30 days, and reviewing it at the end of that time would be a more appropriate remedy in terms of going forward in this case.
My sense is, Judge, so in fairness to Mr. Cox, I was a bit dilatory. His email to me was sent some time ago, and it was my oversight not to follow up with him. So give me a couple of weeks to follow up with Mr. Cox and go through the documentation he's provided and see if there's something else that's going to satisfy the insurance carrier that this was in fact gas purchased from my client's station.
I would say the 30-day adjournment then would sound reasonable to me, Your Honor. I don't know if the court needs to go through a scheduling order if we're going to maybe potentially have resolution.
Given the reality that it seems the parties have effectively pretty much narrowed the issues here, I'll hold off on any formal order of discovery. Moreover, it seems that the respective counsel have been able to kind of work together towards trying to achieve the objectives here. So I'll go ahead and set it over for 30 days. If there's a need for discovery, I think the parties can handle that somewhat informally. But if there's a problem, in 30 days hence, I'll issue a formal scheduling order regarding this matter, and we'll go forward with that. But I'll set it for review in 30 days, and let's see where things are at that time. I think it's reasonable to do that.
Thank
So
you,
the next
Judge.
November 22nd.
November 22nd, 11/22, and that's going to be at 9:45 a.m.
Got it.
Thank you, gentlemen.
Thank you, Judge.
Thank you, Judge. One quick question, Your Honor, on an unrelated matter. Judge Nance, I have a Judge Nance Adams case at 10. Do I just, I'll just log on over at her courtroom and then, okay, very good.
I'll be over there at about 10.
Okay, thank you, Your Honor.
Hey, Keith, give me a call later on, okay?
Very good. Thanks, David.
Okay, thanks. Thank you, Judge.
Thank you. Good day.
Okay, you too.
All right, this is case number 21-241-261. This is Roma Taylor Golston versus Dave Boyle. The matter is before the court on the filing of a petition in order to show cause. The court issued a show cause after entry of judgment in this matter. I believe that there was a previous subpoena regarding this matter as well. Do I have Wilma Taylor Golston on the Zoom?
I am here, Judge.
All right, good morning to you, ma'am. Do I also have Dave Boyle on the Zoom of doing business at Big Dave's Tree Service? Say something if you're here. Anybody representing that entity or anybody here for Dave Boyle? Say something at this time. All right, it looks like the defendant has not appeared regarding this matter. Have you received any payments on the judgment at all, ma'am?
No, nothing.
All right, given that the defendant has not appeared in this matter, the court will issue a bench warrant. Let's see, let's look at your judgment, just 1 second. Yeah, the court will issue a bench warrant and will set bond on the bench warrant in the amount of $6,600. What I'm looking for is your judgment in this matter. You recall what your judgment was?
It was for $4,400, I believe. I don't have that paperwork in front of me.
Yeah, that's, I'm gonna have to make an adjustment. Okay, I'm looking through, I found it. Okay, it was for 4673. So the court's gonna set bond on the bench warrant at $4,800 cash. And ma'am, do you have a bench warrant form, ma'am?
No, I don't.
All right, you're gonna need to get a bench warrant form, and you can email that over to me. Make sure you fill out the appropriate information on that form. Then you send it over to me. I'll put the amounts in, and then we'll get that back to you so that you can take it to the Wayne County Sheriff's Office in the City County Building, and they will effectuate the arrest or whatever is needed in order to execute on the money that is owed.
Okay,
Right? So bench warrant is issued, bond on the bench warrant is $4,800. Let me give you the email address where you want to email that, or you can come down and file it, and then it will get to me, or you can email it. That email address is Latifa, LATIFAH.Hunter is the last name, at 36districtcourt.org.
thank you.
368, 36 District Court, 368. All right.
All right, thank you so much.
Good day to you.
Bye-bye.
Coming to you just a moment. This is case number 21-155-250. This is United Lab and Select Specialist versus City of Detroit. The matter is before the court, set on for review. Your appearance for United Lab, please. Do I have someone from the City of Detroit regarding this matter? When I last called this, I think that the parties were working to get this resolved.
And I'm sorry, Your Honor, I'm with the city of Detroit. This isn't my case, but I can try to get in touch with whatever lawyer is assigned to it.
Yeah, it looks like Patricia Porter is counsel on this matter. And again, Mr. Lowell is the plaintiff's counsel. So if you could check in on one of them and see where they are, or somebody wants to come in and give me an update after. Right.
I will do that. Thanks.
All right, thank you, Ms. Hill. All right, this is case number 22-177-803. This is Huron case management versus City of Detroit. Department of Transportation has issued, but I believe that now it's just the City of Detroit. The matter is before the court, set on for a pretrial conference for Huron. Your appearance at this time.
Your Honor, Mike Xavier on behalf of the plaintiff.
Your P number, if you will, Mr. Xavier, at this time.
Your Honor, P76438.
All right, thank you, counsel. Good morning to you, sir.
Good morning.
For the city of Detroit regarding this matter, please.
Good morning, Your Honor. Philip Hiltner, P77913 for defendant.
Thank you, Mr. Hilner, and good morning again to you, sir.
Yeah. Judge, to correct the record real quick, I believe you called the wrong case number for the case that's before you. Mr. Hiltner and I are on it together. I don't think you have the correct case number, though.
I'm calling 21-168-087.
That's correct this time, Judge. I believe the number you put on the record was a different matter.
You're pointing out a mistake I may have made this morning.
I just want to make sure, Judge, that you called the correct case for the record. God forbid we ever need to get the record. I apologize.
Right, thank you.
All right, Madam Court Reporter, I didn't ask you to say anything. Appreciate it, counsel. Thank you for bringing it to our attention. All right, so what's going on here? I do see answers and what have you. I have not put a schedule on this case, but update me as to where things are at this point.
Judge, the parties have done a fair amount of substantial written discovery. All the claim files and records were exchanged. I don't think any discovery remains in this matter. I did provide my client's bottom line demand back in July. I haven't heard back since, but since the services are no longer continuing, my bill remains the same and my demand remains the same 3 months later.
And Your Honor, I don't think anything really to add to that, other than I believe I've communicated our final top dollar offer to plaintiff's counsel. And I think we're just at different numbers. But that's correct, that it seems like discovery's been completed. Everyone's up to date on all those items.
Sounds good. Have you thought about facilitation or anything, some type of mediated process? You think that would be at all helpful?
Judge, I don't know if it would be helpful. It's not a high dollar case, so I know my client would be unhappy putting about 10% of it towards someone else just for them to facilitate it unsuccessfully. I'm not sure if that would be helpful. I don't know if this court participates in case evaluation or things where it would be a much smaller dollar amount. But facilitation, I think, would be too much of a percentage of the actual value of the claim itself.
And I think my client would feel similarly, Your Honor. If there's some sort of, I don't know, free or very low cost option, I think we'd consider it, but and sometimes it makes it harder to settle because it's like, well, we just spent $1,000 on facilitation. And
yeah, yeah, I understand how that works out. Well, you know, the trick to this is always to switch positions and it is assess the matter from the switch position. If you could stand in the shoes of the other person, what might you think should be the outcome here? How far apart are you? 10%, 20%, 30%?
You know, Judge, I'm not aware of the exact amount of City of Detroit's final top dollar at the moment. So I don't know if this is a jury trial that's been requested. I don't mind the number being put in front of the court right now. I certainly don't want Your Honor to hear it if it's a bench trial.
Yeah, and that's why I didn't ask for a specific number. I was asking relative to percentages, but I'm guessing that there is a jury demand.
And if there is, I'm happy to put the number in front of this court if necessary.
Well, I kind of want to, Mr. Miller, is there a jury demand? I'm looking now.
I was looking for that right now as well.
Just one second. Answer, et cetera.
It doesn't look like it.
Yeah, I don't see a jury.
Then I appreciate the court not asking, Judge.
No, that's why I wasn't sure. That's why you heard me ask about percentage of where, you know, 10% markup, 20%, 30%, so on and so forth. Obviously, if there is a 10% difference, that's easier to bridge than if there's a 50% difference. But again, so I don't want to. I mean, I go ahead and set it up for a bench trial. We can get to this fairly soon and make some decisions on it. Or, I was looking for some ways that you might be able to talk a little bit further, see how far apart you are. If there's some way that you could bridge that. a little bit. But I'll go ahead and set it up for Mitchell. How soon do you want to do this?
Judge, there would likely be, let me look at my notes, a couple depositions of experts one would have to get that order the services provided by the plaintiff. So I would need a little bit of time, given the holidays coming up and it's doctors, I'm going to have to be subpoenaing for video deps. So if possible, we could have one in January that at least give me a time to get through all the doctor's deps and the holidays and get them recorded and prepared for a bench trial.
All right.
And I'd be fine with something in January timeline. I would just point out, I do have a trial scheduled to begin January 10th.
Yeah, okay. Well, let's start the new year off right then. Let's put it on the 3rd of January.
Okay, Judge.
3rd of January, and let's set this on at 9:00 a.m. All right, so 9:00 a.m. January the 3rd, and we'll get going with that right away. I hate to see you all put some more costs into it, because it doesn't sound like it's real far apart. But if that's what has to happen, I mean, that's what we're here for, to try to get to the bottom line. So if you find any room to talk going forward, then let me know, and we'll pull it off. I can get you back for a hearing if you need that. Anything that you need, just reach out, come in on Zoom on any morning, and say that you need the court to drill down on something, to answer something for you, and get right to that.
Judge, just so I'm aware, does the court have any requirements when it comes to either verdict forms or anything regarding witness lists or exhibits prior to us appearing for trial on the 3rd?
Well, I think the appropriate thing to do, of course, is to have your exhibits arranged. We typically a proposed jury instruction, proposed jury verdict form. Typically, what I found is that in the trial setting, unless the parties have stipulated to the verdict form, we'll have to work on that a little bit. Given that the two of you have worked together to exchange information, then you pretty much know what you're going to be trying to put in. If there are any objections, I'll deal with them as
Okay.
as they long.
Okay.
I don't require a trial brief in every case, and this sounds like one where the two of you again working together on this. I'm not going to require a trial brief.
Sure. Does the court offer, Judge? Do you have TVs or things like where video depositions can be played, or would you like us to bring in a third-party service to do it for you?
Yeah, you better bring in a service to do that.
Sure. I'll let them know the schedule then.
Thank you.
Thank you, Judge.
All right, good day to you. I'll see
Thank
you
you.
in January, if not before.
Sounds good.
Thank you, Your Honor.
Thank you. All right, the court now calls case number 22-177-803. This is C-Spine Orthopedics versus City of Detroit. The matter is set on for general hearing. Your appearance for the plaintiff in this matter, please.
Good morning, Your Honor. Christina Abro here on behalf of Plaintiff C-Spine P78224.
Thank you, Ms. Ambrose. Good morning to you, ma'am. For the defendant City of Detroit, your appearance, counsel.
Morning, Your Honor. Ben Patterson on behalf of the City of Detroit, PA5118.
All right, thank you, Mr. Patterson, and good morning to you, sir. All right, so I see that that all of the answers and things along those lines have been in for quite a while. I don't see where I issued a scheduling order, but I think that you're moving along in this case anyway. Is that correct, Ms. Avro?
That's correct, Judge. I have been talking to brother counsel on this. We did exchange some numbers yesterday. I'm waiting to hear back from my client. It is a fairly small bill, around $2,700, a little more than that. So I'm just waiting to hear back. I think if we can get a little more time, even before the scheduling order goes out, I think we should be able to wrap this up. I'm just wanting to see where they're at with the city of Detroit's offer.
Ms. Patterson?
That's fine with me, Your Honor. I just was mentioning to Ms. Abra, sometimes it's helpful to get clients' attentions if a scheduling order gets issued and they see some urgency to it to wrap back with her, but I will defer to her. That is simply her client relationship question. So I would defer to Your Honor if it makes sense to go ahead and issue a scheduling order and get things set, or if you want to put things out 30 days, that's also fine.
All right, so is there some additional items of discovery that are needed? Or the parties pretty much set what they?
Well, Your Honor, we have not done discovery. Your Honor had not issued an order yet, so I believe we have some basic bills from plaintiff. I would probably serve some written discovery. I would anticipate probably a motion if we weren't able to get this resolved, even though it is a small matter.
That's correct, Judge. And for those reasons, that's why I was saying if we could put this out 30 days before that even gets issued, I think that we should be able to get this resolved instead of wasting time and resources on discovery and doing all of that.
Yeah, that's what I'll do. I think it's worth putting a short tail on this, and then let me take another look at it. And if I need to issue a discovery order, et cetera, I'll go ahead and do it. I'll bring this back like 30 days hence. Let me take another look and see what.
November 17th.
November 17th.
Mhm.
11/17, 22, 9:30 a.m. 11/17, 9:30 a.m.
Thank you, Judge.
Setting that for a review, and I'll get updated on where things are, and if we need to move forward with the scheduling order and so on and so forth, I'll deal with that. We'll address those things more. If we need to set a trial and let you guys move forward informally, so we'll figure it out in the next action. Thank you. Good day to both of you.
That's great. Good day, Judge. Thank you.
Thank you, Your Honor.
For the court now calls case number 18-241-991. This is Jones Onowi versus Reina El Hadi. The matter is before the court. Looks like it's set scheduled for a trial on today's date. All right. Your appearance for Jones, please.
Your Honor, I am here in person.
Yes, sir.
David Palmieri, 26796.
All right. Thank you, Counsel. Good morning to you, sir. For defendant in this matter.
The defendant's runner, Michael Elkins, P29725. And there's been some confusion about the scheduling. When we were last here, we were last in court, the court said assigned a pretrial and then a trial date subsequent to the pretrial. I then received a notice from the court about a trial at 10 o'clock, at 9 o'clock today. I called the clerk immediately and was told that whatever had been set for the time was going to be just adjourned to that date. In other words, that the pretrial had been assigned for today's date. So there's been some confusion on our part, apparently, Your Honor, as well as the instructions from the court.
Yeah, I remember setting this, and I remember saying something about a trial date at some point. I was not expecting that it was up today for a trial, but that is what the notice is, and it does say 10 o'clock a.m. Is everybody ready for trial? Let me go to you, Mr. Palmer.
Your Honor, unfortunately, I have to tell you that my client and I have also had some confusion. I expected him to be here with me live so that we could present our testimony to you. And he tells me he's scheduled for another hearing in another court in this building, and he's in that hearing now and tied up for an unknown amount of time.
You're talking about Mr.
Mr. Owenu.
Oweno?
Yes.
Mr. Oweno is on the Zoom. I see him here. Good morning to
Oh,
you.
okay.
Say something, Mr. Oweno.
Yeah, Your Honor.
All right. Good morning to you, sir.
How you doing?
I'm good. I'm good. So I understand you have another case somewhere else this morning as well, correct?
That has been hard. I just had adjournment on that.
All right. You just dealt with that. Okay, very well.
Yes.
So Mr. Elgin, you're not expecting that this would be a trial matter today, correct, sir?
That is correct, Your Honor. I was under the impression that this was going to be not the pretrial where we can address it. And I'd like to report to the court that we actually have some movement. We had to get my client had to get the port police in Lagos involved because they were trying to hold an extortionate amount. They had changed the contract amount for the demurrage from up until about approximately 14 million naira, which is something that was totally out of the question. However, the port police were involved, and the amount was struck, and that amount is being paid today. That will leave moving the truck, the vehicle, the container with the vehicles in it from the port then to where it can be taken and delivered. However, there's been massive flooding in Nigeria in the south, so it may take a day or week to get the truck to move the container.
Yeah, this, where is the car now? It's in Nigeria. Where did you say?
Well, it's been on Tin Can Island, which is the port of entry, main port of entry for Lagos. It's been there for a couple of years, Your Honor. In a container with 3 other vehicles.
Are all 3 vehicles the subject of this dispute, or?
Well, no. This is just one. The other of the 3 vehicle owners are aware of what's going on and have not had an issue.
Counsel?
Would you permit me to address the court without a mask?
Yeah, you go ahead. Sir.
I think I'll be more intelligible that way. The history of this case is that every time we come to court, the defense has new information. It's just about to get the automobile out of pocket. This time, the reliability of not Mr. Elkins, who is beyond reproach, but his informants. We don't know. It seems like they're right on the verge of freeing up that automobile. It is court. What I'd like to say is, court willing, and it's entirely up to Your Honor. I think the parties need to dedicate themselves to getting this case over before Christmas. If the court would give us a date, set it as a trial date, so Mr. Elkins isn't surprised. I understood we had an option. It could either come in live today or it could come on Zoom. Apparently, the people downstairs told me you were on a Zoom docket today. I heard you say that you're going to another courtroom shortly.
Yeah, a panel and another document.
Yeah, and and the only other factor that I would mention is that I started my day this morning in Phoenix, Arizona. I was flying, well, I actually got on a plane at 11:15 last night. I haven't been home yet, and I'm holding myself together with the final expression goes baling wire and spit. So if we don't have to try the case today.
Yeah, that makes sense.
It makes sense, but if Mr. Elkins is had a misunderstanding and disadvantage, that's not fair. So once again, I argue Mr. Elkins' position. I will send him a bill there.
All right, I see your client raising his hand on the screen because obviously I think everybody wants some type of traction here. Sir, you're represented by counsel, and so I don't usually let a person speak that's represented by counsel because that can become a problem. And I'm not gonna let you say too much anyway. So what do you want to tell?
Your Honor, I would want the embassy, the US Embassy in Lagos to get involved. They can find out for us what is going on, but they need a court order. And I've discussed that with my attorney, he knows. We just need a court order for the US Embassy in Lagos. They can go to the ports and give us a report because this has been going on for 5 years. Every day they have a new story. Thank you.
Thank you. So, I mean, it would seem to me if there's a court order that could help this, I mean, I'm willing to sign something that parties stipulate to. But I don't know how that plays out internationally.
I'm very familiar with it. All we need to do is to send an order to the embassy and they will go to the ports and get us a report. These people be doing this for 5 years now. And they have stories every day.
All right, let me talk to your lawyer about it, sir.
Thank you.
Your Honor, with the court's permission, and we will come up with an order in a very short time and submit it to Mr. Elkins to see if he can stipulate to it. If he can, fine. If he can't, I'll file this motion and see if we can get this this method used to get to the bottom of this. And that may help the court in any event. So that's a good idea.
It sounds good, Mr. Elkins. He's going to present a proposal to you to see if there's something that can be done, and if you can stipulate to it, then you get that to me.
We have no problem. We have no problem with that, although I'm curious as to how the judiciary branch has effect on the executive branch. But I'm, as I said, my understanding is that the newly agreed amount with the intervention of the police is going to get the vehicle released as soon as they can get it trucked out. That's going to depend on the water.
Well, our national, to a certain extent, our national politics have turned civics on its head a little bit for all of us. So maybe this is the next migration of that. The judicial impact.
The other concern, Your Honor, is that given how things seem to be working out in Nigeria, if we get another government involved, it's almost guaranteed to build in some delay. I would give us, if you can, a couple of weeks to get it out, to make sure it gets out of there before we entertain trying to order the embassy to do something.
Yeah, all right. I mean, it's playing a tightrope because you're dealing with nations, obviously. What I will do, I'm going to go ahead and set it. I'm going to go ahead and I'm going to actually set it for trial. And hopefully all of this gets worked out. If not, the next time you come, you should try to get here in person. That's at all possible. Okay. And let's put the evidence before me, and let me make some decisions as to what the outcome, what the rule of law is in this case, and the court make some determination. The parties be able to go forward accordingly. Hopefully, it get worked out before that. So I'm going to give you a bench trial date in this year, maybe in November.
Now you probably gonna have to go to December. You can do December. Or December the 6th.
December 6th is what I'm looking at. That's Tuesday, December the 6th.
It's okay with my schedule, Your Honor.
Excuse me, Your Honor.
Just one moment, sir. 12/6, and that's going to be. I'm going to set it at 10:30. Go forward. It's bench trial. Mr. Owen.
I have a court date on that morning at 36 District Court, and it's by Zoom.
And what time is it set for?
It's 9:30, but you know how it is.
Yeah, well, you should be all set by 10:30.
Oh, okay.
Yeah, you should be all set by 10:30. Unless you want me to move it to the 7th. I have the 7th available as well.
7th is fine, Your Honor.
7th is clear with me, Your Honor, it's fine.
And given that it's Pearl Harbor Day, it may be appropriate in this case. Yes, fine.
Hey, they will live in heaven. All right, so 12/7 is the date, 10:30 a.m.
Thank
That
you.
is for bench trial, and hopefully it gets worked out before then, but if not, we'll put it to rest in terms of getting the evidence on, and making a decision in that regard. All right, all the
Thank you.
best. Well,
Thank you, Court.
Judge, can I get the plaintiff's name and P number again? I didn't hear that well. Plaintiff's counsel.
All right, David Palmieri, Palmiere, P26796.
Thank you so much.
I hold the record for the lowest number announced in your court today.
yeah, it's
Feeling my age.
minus 3.9. I thought I was getting somewhere. Yeah, that's back there.
Oh, it's just gray hair.
Yeah, just a teenage boy. All right,
Thank you,
good
Renner.
call. Thank you. Why do I have other people here?
You have another case for 803. City of Detroit against Fine Orthopedics.
I dealt with that already.
Oh, you dealt with that one?
It's fine. You know that right out?
United Lab, that was 250.
Oh, we were waiting on that one. That's,
Oh, we're doing 250, United Lab.
yeah. I called that one and council was trying to find the support. But I have United Lab and Select versus City of Detroit. The suffix is 5250. Anyone from United Lab on the Zoom? Anyone from the City of Detroit? All right, I see Miss Porter coming. Good morning, Ms. Porter, on United Lab versus City of Detroit. Your appearance regarding that matter, ma'am?
Yes, Patricia Porter, P66989 for defendant, City of Detroit.
All right, thank you, Ms. Porter, and good morning to you. I called this earlier, but I didn't hear anybody on the other side. I know Mr. James Lowe was here on a previous occasion. I set it for a review today. Can you update me on what's going on here?
Yes, I can, Your Honor, and I apologize for not being here earlier. The release has been exchanged and it was returned, signed, and now we are processing the documents to issue a check. So it shouldn't be very much longer before we can file a dismissal.
All right, very well. So I'll indicate that the matter is settled. We'll take it off the dock and I'll await a final order.
Okay, that'll be great. Thank you so much.
Thank you. Said we had something else.
Oh, no, that was it. You said we did. Okay.
Mrs. Johnson, why are you on this Zoom, ma'am?
I'm sorry, I was on for my mom, Elizabeth Reynolds. She couldn't get on, and she had a court date today. And so I was just checking the status on it. I do have authorization to speak on her behalf. So I didn't know what had happened or what the purpose of the meeting was today.
What's the case number, ma'am?
I'm sorry, 22180247.
They filed a stipulation in order on 9/23 for dismissal. It's our prejudice they must attend this return. We signed it on 9/23. Court date was removed.
Yeah, the case has been dismissed, ma'am. The court date was removed because the party stipulated order of dismissal has been signed by the court. The case.
So the case has been dismissed?
Yes, ma'am.
Oh, okay.
All right.
Thank
your
you.
update. All right.
I'm
good day
sorry.
to you. I said, that's your update. I said, a good day to you.
Okay, thank you. You guys have a great day.
All right. Bye-bye.
Bye-bye.
Okay.